two-parter tonight. I'm going to give a little more of a fulsome introduction a little bit later, but we're going to start tonight with an overview of the last Supreme Court of the United States term, and we're going to start with Dean Chemerinsky. And you know, he's so well known in legal circles that it's entirely fair to say, and I know it's a cliche, that he needs no introduction. He tells me short. So he's been the dean at the UC Berkeley School of Law since 2017. And that same year, he was named the most influential person in legal education in the United States. Since then, his influence has grown beyond legal circles, including he's authored numerous New York Times opinion pieces. He's authored over 17 books, including his most recent, No Democracy Lasts Forever: How the Constitution Threatens the United States. He's a great friend of the college, having generously donated his time to host webinars and gives lectures. His annual Supreme Court Review lectures are legendary, and we are honored to start our program tonight with that session. Please welcome Dean Chemerinsky. You're going to stand down there? Okay.
Feels too far away to stand up here. Unless I cause lots of feedback and problems by doing this. This is good? Thank you for the kind introduction. Thank you so much for having me. It's an honor and pleasure to be with you. For each of the last 5 years, I've done a book for the American Bar Association at the end of the Supreme Court term. I try to find a theme of the cases and have that reflected in the title of the book. Sometimes that's easy to do. You'll remember the Supreme Court term a few years ago where the justices overruled Roe versus Wade, significantly expanded gun rights, greatly changed the law with regard to the religion clauses. I just titled the book, A Momentous Year in the Supreme Court. The title for the book I wrote on last term is Taking Sides. Our country is more ideologically divided than it's been at any time since Reconstruction. Many of the cases on the Supreme Court's docket last term arose and reflected that ideological divide. There were cases that came from what we call the culture wars. There are cases that involve challenges to President Trump's initial actions as president this term. In virtually all of these cases, the Supreme Court came down on the conservative side of the ideological divide. Now, you might agree with what the Supreme Court did last term, or you might disagree with what the Supreme Court did last term, but I don't think anyone can deny that when you read the cases, there was a real sense it was a term of taking sides. Certainly how it's perceived right now. There was recently a Gallup poll that said that of those who self-identify as Republicans, 75% express approval for the Supreme Court's performance. But of those who identify as Democrats, 11% express approval of the Supreme Court's performance. And that's the largest gap as long as this has been measured. So I think the profound question about the Supreme Court now and going forward is, at a time when our country is so deeply ideologically divided, what will it mean to have a Supreme Court that's come down so solidly on one side of that ideological divide? I thought I would do 4 things in this presentation. First, I want to talk about last term of the Supreme Court by the numbers. I think a lot can be learned from the statistics about the Supreme Court. Second, I want to recap what I regard as the most important cases from last term for the legal system and for our society. Third, I want to talk about the emergency docket of the Supreme Court, what's gone on with regard to the shadow docket, even since last June, is the most significant recent developments about the Supreme Court. Then fourth, I want to preview for you what I think are the most important matters on the Supreme Court's docket so far this year. First, in terms of the numbers. Maybe because I've been obsessed with baseball statistics since I was a child, I'm similarly focused on Supreme Court numbers. Last year, the Supreme Court decided 56 cases with signed opinions after briefing and oral argument. It's almost identical to the year before, when it was 59 cases. But what's significant to note is that in the 1980s, the Supreme Court was averaging over 160 cases a term. In Chief Justice William Rehnquist's last term, October term 2004, the Supreme Court decided 85 cases. To go from 85 cases let alone from 160 to 56, which is really the new normal, is truly remarkable. Another statistic that's stunning is the increase of matters on the emergency docket, the shadow docket. 2 years ago, in October term 2023, for the entire term, the Supreme Court resolved 40 matters on its emergency docket. For last term, as of June 27th, the last day it handed down opinions, it had already resolved 113 matters on its emergency docket. Actually, a Supreme Court term officially continues until the new term starts, which was a week ago Monday, first Monday, October 6th. And if you take the entire term, the Supreme Court had 144 matters resolved on the shadow docket. That's an increase over 100. It's more than a tripling in a year. Some of this, of course, is the very large number of challenges to President Trump's initial actions in this term in office. But it is, I think, a remarkable shift with regard to the Supreme Court. A few other statistics that might interest you. The justice most often in the majority was Chief Justice John Roberts. He was in the majority 95% of the time. He was in dissent only twice all term. The two justices who were most often in agreement were Justices Clarence Thomas and Samuel Alito. They voted together 97% of the time. The two justices next most often in agreement were Justices Sonia Sotomayor and Ketanji Brown Jackson. They voted together 94% of the time. I think this confirms our sense that at this point, just Thomas and Alito are the most conservative, and Justices Sotomayor and Jackson the most liberal justices on the court. One other statistic that I find interesting that's gotten very little attention is that of the 56 cases, only 3 were reviewing state court decisions. All the rest were reviewing federal court decisions. And this isn't a one-year phenomenon. The year before, only 5 were reviewing state court decisions. The term before that, only 4 were reviewing state court decisions. When I speak at state judicial conferences, I'm able to say to the judges, this means there's a very small chance that anything you decide will be reviewed by the United States Supreme Court. But it also has implications in terms of the Supreme Court's docket. Last term was the 4th in a row that there were no cases about searches and seizures under the 4th Amendment. No case about the 5th Amendment privilege against self-incrimination. No cases about the 6th Amendment Confrontation Clause. The vast majority of criminal prosecutions are at the state level. And if the courts are not taking cases from state courts, it really shapes what's going to be on the docket. Well, let me move to the second part of remarks, what I regard as the most important cases from last term. And I said in my introduction that I think what was most significant about last term is the cases that came from the culture wars and the cases that involved President Trump. And so that's what I want to talk about from last term. In terms of the culture war cases, the first that I'd mention was Mahmoud versus Taylor that came down on Friday, June 27th. The Montgomery County school system is one of the largest public school systems in the country. It adopted a curriculum on sexuality, sexual orientation, and gender identity that starts at the young ages and goes through grade 12. Some parents objected to that curriculum. They said that it portrayed gay, lesbian, and trans individuals in a favorable light, and that this was inconsistent with their religious beliefs. They said it violated their free exercise of religion to not have notice of this curriculum and the opportunity to opt out. The federal district court ruled against the parents. The United States Court of Appeals for the Fourth Circuit affirmed, but the Supreme Court, in a 6-3 decision, reversed and ruled in favor of the parents. Justice Alito wrote the opinion for the court. Justice Sotomayor wrote for the dissents. Justice Alito agreed with the parents that it violated their free exercise of religion to not be given notice of the curriculum and to opt their children out. He said the free exercise clause protects the right of parents to control the religious upbringing of their children. He relied on a case in the 1970s, Wisconsin versus Yoder. It involved a Wisconsin law that required that children attend school to age 16. Amish parents said it infringed their free exercise of religion to require that their children be schooled after the 8th grade. the Supreme Court ruled in favor of the Amish parents. Justice Alito said Wisconsin versus Yoder was controlling in this case. He said because there's an infringement of free exercise of religion, Montgomery County would have to meet strict scrutiny. It'd have to show that its action is necessary to achieve a compelling purpose. He said the government failed strict scrutiny. Justice Sotomayor wrote very strong dissent. She said, this is the first time in history that the Supreme Court has ever held that mere exposure to material is in itself an infringement of free exercise of religion. Justice Sotomayor said, this decision is going to create, quote, chaos in public school systems. He said, given how diverse our country is with regard to religion, how is a school system going to know when it has to give notice to parents and the chance to opt out? Does this mean that every time evolution is taught in a science or biology class, parents have to give notice and opt out? Does this mean that any time in an English class there's a book with witches or witchcraft, like Harry Potter, parents have the right to notice and opt out? Justice Sotomayor said, some religions believe that mothers should not work outside the home. Does this mean that parents have the right to notice and opt out anytime in a history class there's a favorable portrayal of a working mother? I think what's most significant about this case is that there's not a limiting or cabining principle in Justice Alito's majority opinion. It very much opens the door for any parent, based on any religious belief, to say, I object to my children being exposed to this in school. I therefore have the right for them to opt out. Justice Sotomayor questioned, can public schools really operate on that cafeteria basis? Will they only then have to teach that which no one might object to? The other case from last term that very much arose from the culture wars was United States versus Scrimetti. It involved a Tennessee law that prohibited gender-affirming care for transgender youth. Specifically, this was about Tennessee prohibiting puberty-blocking hormones or cross-gender hormones from being prescribed to transgender youth. A federal district court judge in Tennessee issued a preliminary injunction saying this is likely unconstitutional. He said this is sex discrimination, and he said this is gender identity discrimination. He said both should receive intermediate scrutiny. Under intermediate scrutiny, a government action has to be substantially related to an important government purpose, and there has to be an exacting inquiry to make sure that there is an important actual purpose being served. The district court judge said, reviewing the weight of scientific and medical evidence, the Tennessee law should be declared unconstitutional. The United States Court of Appeals for the Sixth Circuit reversed. Chief Judge Jeffrey Sutton wrote the opinion for the court. He said there should be deference to the Tennessee legislature and that therefore the law should be upheld under rational basis review. On Wednesday, June 18th, the Supreme Court, in a 6-3 decision, affirmed the Sixth Circuit and upheld the Tennessee law. Chief Justice John Roberts wrote for the court. Justices Thomas, Alito, and Barrett wrote concurring opinions. Justice Sotomayor wrote a dissent, drawn by Justices Kagan and Jackson, and Justice Kagan wrote a short dissent for herself. There were two issues before the Supreme Court, as there were before the lower courts. First, is this law sex discrimination? Chief Justice Roberts said no. He said the law prohibits gender-affirming care for both boys and for girls, therefore it can't be said to be sex discrimination. Justice Sotomayor strongly disagreed. She says there's drugs that are given to boys that can't be given to girls, drugs that are given to girls that can't be given to boys, said that's sex discrimination. If a boy has delayed puberty, he could be given testosterone to enhance his male characteristics, but a girl who is transitioning couldn't be given testosterone to enhance male characteristics. A girl who has delayed puberty could be given estrogen to enhance female characteristics, but a boy who is transitioning couldn't be given that drug to enhance female characteristics. Said that's sex discrimination. The second issue before the Supreme Court was whether this is discrimination based on gender identity, and if so, what level of scrutiny should be used for for discrimination based on gender identity. Chief Justice Roberts said it's not discrimination based on gender identity, and therefore the court didn't have to resolve the unanswered question, what level of scrutiny for gender identity discrimination? Chief Justice Roberts came to this conclusion by invoking a Supreme Court decision from 1974, Geduldig versus Aiello. Geduldig versus Aiello involved a California law that concerned when could state employees get disability payments for medical conditions. And the California law paid for all medical conditions that led to disabilities, but not pregnancy-related disabilities. And the issue before the Supreme Court was excluding pregnancy sex discrimination. And the Supreme Court said no. Justice Potter Stewart wrote the opinion for the court, and Justice Stewart said, there's two categories of people. There's pregnant persons and non-pregnant persons. He said, since women are in both categories, it can't be sex discrimination. Well, some of you just laughed when I said that. When I teach this class at Case every spring, my students laugh at that as well. Well, Chief Justice Roberts said that these hormones can be prescribed to all individuals for certain medical conditions, but they can't be given to transgender youth for gender transition purposes. He said since transgender individuals are in both categories, it's not discrimination based on gender identity. Justice Sotomayor said, essentially, that this is one of those ridiculed Supreme Court decisions in history, Geduldig versus Aiello, and we shouldn't be relying on it. She quoted Justice Ginsburg, that it was wrong as decided, and it's wrong today. She said the whole purpose of the Tennessee law was to discriminate against transgender individuals. So the Supreme Court didn't resolve the question of what level of scrutiny to use for discrimination based on gender identity. As I'll talk about, it's an issue back before the Supreme Court this term. But Justices Thomas, Alito, and especially Barrett wrote separate opinions saying they believe it should be only rational basis review for discrimination on the basis of gender identity. It was a powerful dissent by Justice Sotomayor. She wrote, not respectfully I dissent, but with sadness I dissent. I think it's a case that will have great implications. For instance, President Trump signed an executive order that prohibits transgender individuals from serving in the military. The district court found this likely unconstitutional and issued a preliminary injunction. The Court of Appeals affirmed, but the Supreme Court 6-3 reversed. The Trump administration has adopted rules to try to prevent gender-affirming care for transgender youth. A number of hospitals, including Children's Hospital Los Angeles, have stopped providing gender-affirming care. I think that the Trump administration actions likely will be deemed constitutional in light of Scrimetti. Well, I said I thought that the two most important areas of development last term were the culture war cases and the Trump cases. And the key case with regard to President Trump was Trump versus Casa, decided on Friday, June 27th. On January 20th, his first day in office, President Trump issued an executive order greatly restricting birthright citizenship. Little bit of background. When the United States began in 1787, it followed English law that everyone born in the country was a citizen of the country. The Supreme Court tragically departed from this in Dred Scott versus Sanford in 1856. There, the Supreme Court held that enslaved individuals were not United States citizens, even if born in this country. When the 14th Amendment was drafted and then ratified in 1868, the first sentence of Section 1 was to overturn Dred Scott versus Sanford. It says, all persons born or naturalized in the United States and within the jurisdiction thereof are citizens of the United States in the states wherein they reside. In 1898, in United States versus Wong Kim Ark, the Supreme Court said the first sentence of the 14th Amendment means that everyone born in the United States is a United States citizen, regardless of the immigration status of their parents. The Supreme Court said the phrase within the jurisdiction thereof simply means if there was an invading army and a soldier had a baby, or the foreign diplomat had a baby, they wouldn't be United States citizens. But otherwise, everyone born in this country is a citizen. And that was followed without question or exception until January 20th, when President Trump issued his executive order. Essentially, it says that only those born to citizens or those with green cards are United States citizens. Challenges were immediately brought in several federal district courts. Everyone declared this unconstitutional, and several issued nationwide injunctions. The courts of appeals upheld this. The Solicitor General's office did not ask the Supreme Court to rule on the constitutionality of the executive order with regard to birthright citizenship. Instead, the Solicitor General's office said it was making, quote, a modest request to the Supreme Court. It said it wanted the Supreme Court to declare nationwide injunctions unconstitutional. The Supreme Court took the matter off the emergency docket. It had full briefing. It held oral arguments on Thursday, May 15th, and then handed down the decision. The court did not decide it as a matter of constitutional law, but rather of statutory law. Justice Amy Coney Barrett wrote the opinion for the court. Justice Thomas Alito and Kavanaugh wrote concurring opinions. Justice Sotomayor wrote a blistering dissent, joined by Justice Kagan and Jackson, and Justice Jackson wrote her own separate blistering dissent. I thought the easiest way to discuss the case was to compare the majority and dissenting opinions to see the areas where they disagree. First, they disagreed about methodology. Justice Barrett in the majority opinion said, this is a question of what the Judiciary Act of 1789 empowered federal courts to do. She said, we have to answer this question by looking to whether the High Court of Chancery in England in the 18th century could issue nationwide injunctions. She said the High Court of Chancery in England in the 18th century couldn't do this, so federal courts don't have that power under the Judiciary Act of 1789. Justices Sotomayor and Jackson strongly disagreed with that methodology. Justice Jackson said, in England, no court could strike down in actions of the king. Why then should we look to English law from the 18th century to define the powers of the federal courts today to restrain the president? Second, the majority and the dissent disagreed over the history. Justice Barrett in the majority opinion said that nationwide injunctions are a recent development. They've grown tremendously in recent years, and that indicates that they're impermissible. Justice Sotomayor in her dissent said, in England, there was the Bill of Peace, which was functionally like a nationwide injunction. Justice Sotomayor said, courts of equity have always had broad discretion to ensure complete relief for the parties. And she said, actually, nationwide injunctions have existed in federal courts since the early 20th century and gave many examples over the last 100 years. And third and finally, the majority and the dissent disagreed over the relevance of consequences. Justice Barrett in the majority opinion said the court was not going to, quote, look at the pros and cons with regard to universal injunctions. But the dissent was very much focused on the consequences. Most of all, the dissent said, at a time when we have a president who's challenging constitutional limits, the Supreme Court is limiting the powers of the federal judiciary to restrain the president. Justice Jackson spoke of this being a threat to the very rule of law. The dissent pointed to other practical consequences. Does this then mean that if there's a challenge to a presidential action, there has to be a separate lawsuit brought in all 94 federal districts? Does this mean the dissent asks if many federal district courts declare a presidential act unconstitutional, the president can keep doing it everywhere else in the country until ultimately the Supreme Court rules? How much will this case matter? I think it'll depend on whether there are alternatives that develop that can achieve the same thing as nationwide injunctions. Justice Sotomayor in her dissent very much questions that. But what about nationwide class actions? What about the ability of a state attorney general to sue on behalf of the residents in the state? What about the ability of a federal court to vacate an action under the Administrative Procedures Act? Justice Barrett was explicit that the Supreme Court was not addressing them. Justices Thomas and Alito each wrote a concurring opinion saying, federal district courts don't use these alternatives to nationwide injunctions. We mean to disapprove of these as well. We'll see what the Supreme Court says as it comes to it. But I think there's no doubt that it does lessen the ability of federal courts to restrain presidential and congressional actions. No longer can there be nationwide injunctions. In the third part of my remarks, I want to talk about the emergency docket of the Supreme Court. I already gave you the statistics of the tremendous growth with regard to the emergency docket. And I want to talk about a lot of the things the Supreme Court has done on the emergency docket just over the last several months. And here, what I want to do is try to persuade you that whether you see yourself as liberal or conservative, you should be very concerned with what the Supreme Court is doing on its emergency docket. When a matter comes and is resolved by the Supreme Court on its emergency docket, there's not full briefing, there's not oral arguments. The justices not meet as a group and deliberate before issuing their ruling. When there's oral arguments in the court, as there were this week, the justices meet in conference and discuss. Not so for rulings on the emergency docket. Well, three things are of particular concern to me. One is the Supreme Court implicitly overruling long-standing precedents in rulings on the emergency docket. Here I want to point to an example, Trump versus Wilcox. Gwen Wilcox is commissioner on the National Labor Relations Board. Her term extends to 2008, and there's a federal statute that says she can be fired only for cause. Kathy Harris is the head of the Federal Merit System Protection Board. Her term continues, and there's a statute that says she can be fired only for cause. President Trump fired both of these individuals without any claim of cause. He says it's a unitary executive, and he has the power to fire anyone in the executive branch of government. The problem with that is, in 1935, the Supreme Court decided Humphrey's executive versus the United States. There, the Supreme Court held that Congress can create federal agencies, and Congress can provide that the heads of those agencies are removed only for cause. That case involved a commissioner on the Federal Trade Commission, and the Supreme Court unanimously upheld a federal law that limited removal to when there was just cause, and that was defined in the statute. For 90 years, Humphrey's executor has been the law. Nonetheless, President Trump fired Gwen Wilcox and Kathy Harris. The federal district court issued a preliminary injunction saying that the firings were impermissible. Each operated under a statute identical in language to that from Humphrey's executor. The United States Court of Appeals for the District of Columbia Circuit, in a 7-4 en banc ruling, ruled in favor of Wilcox and Harris. But the Supreme Court, in a 6-3 ruling on its emergency docket, reversed. It was a very short opinion of the court, and it simply said that it was likely that President Trump would ultimately prevail on the merits. As Justice Kagan said in her dissent, this is the Supreme Court implicitly overruling a 90-year-old precedent without the benefit of briefing and argument. And she said, if the Supreme Court is going to overturn a precedent, it shouldn't be on the shadow docket. Second concern that I have with regard to the emergency docket of the Supreme Court is that the court now treats its rulings on the emergency docket as binding precedents on the lower courts. And we've seen this a couple of times. One involved what I was just talking about, the removal power. And this is a case from July on the emergency docket, Trump v. Boyle. It involved the members of the Consumer Product Safety Commission. There, too, a statute exists that says the members can be fired only for just cause. President Trump fired all of them without any claim of cause, again, based on his assertion of a unitary executive. The district court said that this was impermissible, citing Humphrey's executor. The D.C. Circuit agreed, but the Supreme Court in a 6-3 ruling, said that it was going to stay the district court's preliminary injunction, allow President Trump to fire the members of the Consumer Product Safety Commission. And the Supreme Court explicitly said that the lower courts should have been guided by what the Supreme Court said in Trump versus Wilcox, the ruling on the emergency docket. We saw this also with regard to the ability of the president to refuse to spend money appropriated by Congress. On Friday, April 4th, the Supreme Court handed down a ruling in Department of Education versus California. This involved the Department of Education cutting off $65 million of teacher training grants, and a federal district court in Boston issued a temporary restraining order saying President Trump lacked the authority to refuse to spend this money appropriated by Congress. The First Circuit said, as a federal court of appeals, we don't review temporary restraining orders. We have to wait until there's a preliminary injunction. Nonetheless, the Supreme Court stepped in and 5-4 stayed the preliminary injunction. Roberts joined here with Sotomayor, Kagan, and Jackson in dissent. There was a very short, few paragraph opinion, and it said that grants from the federal government are like contracts. Breach of contract actions of the federal government have to go to the Federal Court of Claims. Therefore, this should have to go to the Federal Court of Claims. And then, in a paragraph, the court said, if the federal government has to disperse this money, and that's later found to be an error, how it recoup the funds. On Thursday, August 21st, the Supreme Court handed down another ruling on the same subject. It was National Institutes of Health versus American Public Health Association. Federal District Court judge in Boston, Judge William Young, found that the Trump administration violated the Administrative Procedures Act when the National Institutes of Health cut off hundreds of millions of dollars of grants. He found that this was done in a manner that was arbitrary, capricious, and an abuse of discretion. The United States Court of Appeals for the First Circuit didn't stay the preliminary injunction, but the Supreme Court, in a 5-4 ruling, did stay the preliminary injunction. Short, less than one page, per curiam opinion said that just as we said in Department of Education versus California, grants are like contracts. Challenges to breach a contract by the federal government has to go to the United States Court of Federal Claims. And besides, how will the federal government recoup the money if the court order turns out to be wrong? Justice Gorsuch wrote a stunning concurring opinion chastising Judge Young and more generally chastising federal district courts and courts of appeals for not following Supreme Court rulings from its emergency docket. Until recently, I would have thought that rulings by the Supreme Court on the emergency docket aren't binding precedents on lower courts. In fact, 3 years ago, Justice Alito gave a speech at Notre Dame Law School about the shadow docket, in which he explicitly said they're not binding precedents on lower courts. But what the Supreme Court has done in just the last few months is say lower courts are bound by those rulings. And third and finally, I'm very troubled that the Supreme Court is now issuing major rulings with life and death consequences without the slightest explanation. Let me give you a few examples of this. One is the Department of Homeland Security versus DVD from June 23rd. This involves the authority of the Trump administration to deport individuals from Venezuela and Cuba to South Sudan. Federal district court judge in Boston found that this was illegal. There's a federal statute that prescribes where people can be deported to. There's 6 different categories of places, starting where did the person come from, where are they a citizen, where are they born, and so on. And the judge said that the Trump administration failed to follow that statutory language. And the judge expressed concern that these individuals could face torture or death if taken to South Sudan, a country where they had no prior contacts. The First Circuit didn't stay the preliminary injunction, but the Supreme Court, in a 6-3 order, did stay the preliminary injunction, allowing these individuals deported to South Sudan. There was no opinion. There wasn't a word of explanation from the court. Second example of this was McMahon versus New York in July. President Trump announced he was going to eliminate the United States Department of Education and fired a couple of thousand employees to effectuate this. Federal District Court in New York issued a preliminary injunction. The district court said, Congress created the Department of Education. Only Congress can eliminate the Department of Education. The United States Court of Appeals for the Second Circuit didn't stay the injunction, but the Supreme Court, in a 6-3 ruling, stayed the preliminary injunction, allowing President Trump to fire these individuals and effectively eliminate the Department of Education. There was no opinion of the court, not a word of explanation. In one more example of this, and this is Nome versus Perdomo that came down on Monday, September 8th. A federal district court in Los Angeles, Judge Frimpong, found that ICE agents were violating the Fourth Amendment by stopping individuals without reasonable suspicion. The Fourth Amendment means that any law enforcement personnel, police, ICE agents, have to have reasonable suspicion for a stop. And she issued a preliminary injunction, and she said ICE agents were relying on 4 factors, and none of these can be used individually in combination. The 4 factors were a person's apparent ethnicity or race, the language they spoke and whether they had an accent, the type of job they worked, and where they were found. The government went to the Ninth Circuit seeking a stay of the preliminary injunction. On a Monday, the Ninth Circuit held oral arguments. On Friday of that week, the Ninth Circuit, in a 55-page opinion, affirmed the district court. On Monday, September 8th, the Supreme Court, 6-3, stayed the preliminary injunction. No opinion of the court, not a word of explanation from the court. Justice Kavanaugh wrote an opinion just for himself. Justice Sotomayor wrote a vehement dissent, joined by Justice Kagan and Jackson. I'm teaching criminal procedure this semester at Berkeley, and so the day after the case came down on Tuesday, September 9th, I began class with it because we're very much talking about the standard for stops, reasonable suspicion. And in the class discussion following, and I have about 200 students in the class, a woman raised her hand and said, my father lives in Los Angeles. He's Latino. He's a citizen. He's retired now, and he likes to do projects around the house. He's often going to places like Home Depot. She said, I'm afraid every day that he's going to be apprehended. And she burst into tears. Another student in the classroom had a similar experience. The next day, a student in the class came to me. His mother had been apprehended in Los Angeles, though thankfully she released a couple of days later. This again is a case with huge human significance, but no explanation from the court. Because I said so was not persuasive to any of us as children. It doesn't become more persuasive when it comes from the Supreme Court. Judicial opinions matter. They indicate that the ruling is not just an exercise of power and fiat, but is reasoned deliberation was the basis for it. It gives guidance to the parties, to the public, to lower courts. And so it's very troubling to me that one of the things the Supreme Court is doing on its emergency docket is handing down these rulings without even a word of explanation. Well, finally, and fourth, let me shift and talk about this term and what's on the docket. And I want to look at 3 areas. I want to talk about a civil rights case that was argued earlier this week that has the potential for being the most important civil rights decision in decades. I want to talk about some cases that arise from the culture wars. And then finally, I want to talk about cases involving challenges to what President Trump is doing. The civil rights case is Louisiana versus Calais. In 1976, in Washington versus Davis, the Supreme Court said, in order to show discrimination under equal protection, there has to be proof of a discriminatory intent. The Supreme Court ruled and later reaffirmed several times that proof of a disparate impact is not enough to show race discrimination. It's very difficult to prove discriminatory intent. Rarely do legislators or policymakers any longer express explicitly a racist purpose. We all know now a lot about implicit bias and unconscious racism. There are several federal statutes, and many states have laws that allow proof of discrimination and liability on showing of disparate impact. Title VII of the 1964 Civil Rights Act with regard to employment discrimination, the 1968 Fair Housing Law, and the 1982 amendments to Section 2 of the Voting Rights Act. In 2009, in Ritchie versus DeStefano, Justice Scalia wrote a concurring opinion. Ritchie versus DeStefano was an employment discrimination case under Title VII. And Justice Scalia suggested that disparate impact liability violated equal protection. He said that he believed that equal protection required that decision makers be colorblind. He said disparate impact liability required that decision makers take into account race to avoid liability. He said that should make disparate impact liability unconstitutional. That's the issue in Louisiana versus Clay, whether or not the disparate impact liability under Section 2 of the Voting Rights Act violates equal protection. Here's the background with regard to the case. After the 2020 census, Louisiana engaged in redrawing congressional districts, just like every jurisdiction engaged in redistricting based on the census. There are 6 congressional districts out of Louisiana. Louisiana has a population that's about 35% black individuals. 1 out of the 6 congressional districts was majority black individuals. A challenge was brought that this violates Section 2 of the Voting Rights Act. Section 2 of the Voting Rights Act says, state and local governments cannot have election practice or systems that discriminate on the basis of race. The 1982 amendments make clear that disparate impact liability is sufficient. The district court found that having only 1 majority black district out of 6, given the population of Louisiana, violated the Voting Rights Act. The Louisiana legislature then redrew districts and created 2 districts that were majority black individuals. A group of plaintiffs who called themselves non-minority individuals brought a challenge against this. They said it violates equal protection for the government to use race as a predominant factor in drawing districts, and that's what Louisiana did in drawing 2 majority black districts. The Supreme Court granted review and heard the case last term. And everyone was surprised on June 27th when the Supreme Court didn't decide it. Tradition is that the Supreme Court will decide the cases argued in that term by the end of June. But there are some notable exceptions to that. Brown versus Board of Education was argued in October term 1952. The court didn't decide it then, put it over for re-argument, and decided the following term on May 17th, 1954. Roe versus Wade. It was argued in October term 1971, was not decided that term, put over the following term and decided in January of 1973. Citizens United is another case that was argued one term, decided the next. It certainly suggests that Louisiana versus Clay could be a momentous ruling. That sense was confirmed when on August 1st, the Supreme Court issued an order asking for new briefing and argument on the question of whether Section 2 of the Voting Rights Act is unconstitutional in allowing for disparate impact liability. The case was argued earlier this week on October 15th. Read the transcript of the oral argument. My sense is that the Supreme Court is going to narrow or perhaps strike down Section 2 of the Voting Rights Act. It's not clear how they will do so. But if they reach the question presented and declare Section 2 unconstitutional, allowing disparate impact liability, that will then put in jeopardy all laws, federal and state, that allow disparate impact liability. It will be one of the greatest setbacks with regard to civil rights litigation in decades. Second area of cases on the docket this term I want to mention are the culture work cases. And again, this term, like last term, there are cases that have to be seen as arising from that. One was argued a week ago Tuesday, I think. We go Wednesday, Childs versus Salazar. It involves a Colorado law that prohibits conversion therapy for gay, lesbian, and transgender youth. Colorado adopted this statute based on the overwhelming weight of medical and psychological evidence that conversion therapy is ineffective and harmful to gay, lesbian, and transgender youth. Challenge was brought saying that this violates freedom of speech of therapists, that if they want to engage in such conversion therapy, they should have the right to do so. The United States Court of Appeals for the 10th Circuit, in a 2-1 decision, upheld the Colorado law. The majority said the government restricts speech of professionals in many ways. Doctors, before they perform medical procedures or prescribe drugs, have to provide information so there's informed consent. The law is clear that if a therapist knows that a patient is likely to commit harm to another, the patient has to warn that person of the possible harm. The Supreme Court granted review, and my sense based on the oral argument is that the Supreme Court is likely to strike the Colorado law down as unconstitutional. It's possible that the court might not reach that. The Colorado law went into effect in 2019, and it's never been applied or enforced by Colorado, but it didn't seem that a majority of the justices were focused on that at all. The other cases that come very much from the culture wars are 2 cases that involve state laws that prohibit transgender youth from participating in sports that correspond to their gender identity. What these laws are really about is prohibiting transgender girls and women from participating in girls and women's sports. Cases that are Little versus Hecox that involves an Idaho law, and West Virginia versus PBJ. The United States Court of Appeals for the 9th Circuit and the United States Court of Appeals for the 4th Circuit, respectively, declared these laws unconstitutional as discrimination on the basis of gender identity, and the Supreme Court has granted review. I think that these cases will have the court identify what's the level of scrutiny to be used for gender identity discrimination, but I also think that these are cases where we get a sense of what the court's likely to do based on rulings in matters like Scrimetti. And final matters that I was going to talk about from this term are the many cases that involve challenges to what President Trump has done. There are already several on the docket. There are likely to be a number more. There are a couple of cases on the docket involving the president's removal power. Remember, I mentioned that in 1935 in Humphrey's Executor, the Supreme Court said that Congress can create agencies and Congress can say members of the agency removed only for cause. Well, Trump versus Slaughter involves a commissioner on the Federal Trade Commission. His term continues. He fired under the statute only for cause. Same statute as in Humphrey's Executor. And President Trump removed him. The lower courts ruled in favor of Slaughter based on Humphrey's Executor, and the Supreme Court has granted certiorari. The Supreme Court has granted certiorari on 2 questions. First, should Humphrey's Executor be overruled? And second, does a federal court have the authority to reinstate an individual into office once removed by the president? The other case involving removal is Trump versus Cook that will be argued in January. Lisa Cook is a governor on the Federal Reserve Board. President Trump has removed her. There's a statute that says that governors on the Federal Reserve Board can be removed only for cause. President Trump here has asserted cause that Lisa Cook had engaged in mortgage fraud. The district court ruled in favor of Lisa Cook, issued a preliminary injunction against her removal. The D.C. Circuit affirmed, and the Supreme Court has allowed that to stand while the matter is being litigated before it. I mentioned to you earlier in talking about the shadow docket, Trump versus Wilcox, and I said there was a short opinion. At the end of the opinion, there's a couple of paragraphs where the Supreme Court said, the Federal Reserve Board is different. This is something that's essentially existed since the first and second banks of the United States early in American history. And that was curious because Trump v. Wilcox had nothing to do with the Federal Reserve. As I told you, as a commissioner on the National Labor Relations Board and the head of the Merit System Protection Board, why did the Supreme Court address the Federal Reserve in that case? I think the conventional wisdom is that the court wanted to reassure the stock market. It wanted to let people know that President Trump couldn't go forward with his threat to remove Jerome Powell. But now the issue is squarely before the Supreme Court. Can the president fire a member of the Federal Reserve? Or what does it mean to have just cause? Another set of matters that are already before the Supreme Court this term involve the president's authority to impose tariffs. This has been such a key part of Trump's economic policies. These cases are not likely constitutional cases, but they're the authority of the president to impose tariffs under statutes. And the two cases, and they're combined, and they're going to be argued in November, are Learning Resources versus Trump and Trump versus the U.S. elections. In the latter, the United States Court of Appeals for the Federal Circuit, in a 7-4 en banc, said that President Trump lacked the authority to impose these tariffs. The Federal Circuit said that when a statute is meant to give the president the power to impose tariffs, it uses the word tariffs. This law does not. Also, the Supreme Court has created the major questions doctrine, which says that an agency can act, the executive branch can act on a major question of economic or social significance only with clear guidance from Congress. And there isn't such guidance in these statutes as the power to impose tariffs. And the Federal Circuit said the power to tax is quintessentially given to Congress under Article 1 of the Constitution, and tariffs are a form of tax. President Trump is arguing that under the statutes, he can declare an economic emergency and impose tariffs, and he's also saying he has the inherent authority under Article 2 of the Constitution. Now, these cases that I just mentioned have already had cert granted. The Trump v. Slaughter will be argued in November. In December, the tariffs cases in November, and Trump v. Cook in January. But I think there's a number of other matters that are going to come to the Supreme Court this term with regard to actions of President Trump. One of these is the ability of the president to invoke the Alien Enemy Act of 1798. The Alien Enemy Act of 1798 says, if the United States is in, quote, a declared war or faces imminent military invasion, then the government can summarily deport, quote, males over the age of 14. This is a law that's been invoked 3 times in American history, during the War of 1812, during World War I, and World War II. President Trump invoked it to deport individuals from Venezuela without providing any due process. Late on a Friday night, actually 1 a.m. in the morning on a Saturday, in AARP versus Trump, the Supreme Court stayed the use of the Alien Act until the United States Court of Appeals for the Fifth Circuit could rule. It's about a month ago, the Fifth Circuit ruled in a 2-1 decision that President Trump could not use the Alien Enemy Act. That's going to come to the Supreme Court, I think, this term. Also, 2 weeks ago today, the Solicitor General asked the Supreme Court to take up the merits of the constitutionality of President Trump's executive order on birthright citizenship, the issue that wasn't before the court in Trump v. Casa. And then there's the authority of President Trump to deploy military troops in cities, including for being used for domestic law enforcement. We've had a federal district court in San Francisco, Judge Charles Breyer, a federal district court in Portland, Judge Karen Immergut, finding that what was done in using the troops in this way is a violation of the Posse Comitatus Act. I think this, too, will come to the Supreme Court this term. I've been a law professor a long time now. This is my 46th year as a teacher. But I've never seen a Supreme Court term, never faced a Supreme Court term, where it's such a sense of what the Supreme Court is going to do is very crucial to the future of our constitutional democracy. Thank you.